Welcome to Chapter 6, Intentional Torts and Business Torts. A wide variety of intended acts can have unintended consequences. With intentional torts, the defendant may not have intended to harm the plaintiff, but her deliberate actions have resulted in alleged injury. Anticipating the harm that can result enables us to consider carefully the actions themselves. Consider the case of Jane Doe and Nancy Rowe versus Lynn Mills. Late one night, an anti-abortion protester named Robert Thomas climbed into a dumpster located behind the Women's Advisory Center, an abortion clinic. He found documents indicating that the plaintiffs were soon to have abortions at the clinic. Thomas gave the information to Lynn Mills. The next day, Mills and Sister Louise Mitterrage created the signs using the women's names, indicating that they were about to undergo abortions and urging them not to, quote, kill their babies, unquote. Doe and Rowe, not their real names of course, sued, claiming intentional infliction of emotional distress, as well as breach of privacy. The trial court dismissed the lawsuit, ruling that the defendant's conduct was not extreme and outrageous. The plaintiffs appealed. The question is this: have the plaintiffs made a valid claim of intentional infliction of emotional distress? The court acknowledged that the defendants have a right to express their views on abortion. What they do not have a right to do is publicize the names of these women and the fact they were about to undergo abortions. That is purely private information of no interest to the general public, and that in turn means that the defendants had no right to divulge it. Does the appeals court ruling mean that the plaintiffs have proven their case of intentional infliction of emotional distress? No. The ruling simply means that the plaintiffs are entitled to a jury trial. The court is ruling that the trial court should not have dismissed the case. A jury could legitimately consider this conduct extreme and outrageous. Now it will be up to a jury to decide whether the conduct really does meet that standard. Tort simply means wrong. A tort is a violation of a duty imposed by civil law. An example of defamation is making a false statement about someone, written or verbal. An example of negligence is performing wrong surgery. Stealing a client away from a competitor is an example of interference with contract. And offering to sell something that doesn't exist is an example of fraud. Criminal law is behavior classified as dangerous to society. It's prosecuted by the government, whether the victim wants to prosecute or not, and any monetary award goes to the government. Contract law is based on a breach of an agreement between two parties. The victim prosecutes and receives compensation or restitution. Tort law is based on an obligation imposed by the law with no agreement needed between the parties. The victim prosecutes and receives compensation or restitution. Intentional torts does not require an intention to harm the victim, only an intention to perform the act which causes the injury. Intentionally throwing an object but not meaning to hit anyone is a tort if it causes injury to someone. This includes business torts, a category of torts perpetuated almost exclusively by business entities. Cottle versus Betts. Cottle worked at a Betts Lincoln Mercury dealership. During an office party, many of the employees, including President Betts, were playing with an electric auto condenser, which gave a slight electric shock when touched. Some employees played catch with the condenser. Betts shocked Cottle on the back of his neck and then chased him around, holding the condenser. The shock later caused Cottle to suffer headaches, pass out, and eventually require surgery on a nerve in his neck. Even after the surgery, Cottle had a slight numbness on one side of his head. He sued Betts for battery. Betts defended by saying that it was all horseplay and that he had never intended to cause injury. What would you rule? Although the trial court ruled for Betts and the Court of Appeals affirmed, the Louisiana Supreme Court ruled for Cottle. The court held that it was irrelevant that Betts had shown no malice toward Cottle nor intended to hurt him. Betts intended the physical contact with Cottle. Although he neither expected nor could reasonably have foreseen the medical damage Cottle suffered, Betts was still liable for all the consequences of the physical contact he did intend. You may reason that a defendant cannot be liable for an intentional tort if he didn't intend the harm. Betts, all in fun, shocked Cottle on the neck with an electric auto condenser, resulting in chronic injuries to Cottle. Cottle sued Betts for battery, and after trial and intermediate appellate court decision for Betts, the Louisiana Supreme Court finally got it right and ruled for Cottle. Betts' lack of actual intent to harm Cottle was irrelevant. He intended to shock Cottle with the condenser and is liable for the consequences. Defamation is irresponsible speech to harm another person's reputation. If it's written, it's libel. If it's verbal, it's slander. There are 4 facts to prove in order to win a defamation suit. The defamatory statement has to have actually been made. The statement that's made has to be false. The statement has to have been communicated to someone other than the plaintiff. And in slander cases, the plaintiff must show some injury that resulted from the defamation. Sometimes a slanderous statement is so harsh and potentially damaging that the plaintiff is assumed to be damaged and does not have to prove injury. For example, if someone were to accuse you of committing a serious crime, or accuse you of having a sexually transmitted disease, or accusing you of being an unchaste woman if you're female, or charges you with professional incompetence. Sometimes public personalities like politicians and movie stars have a hard time winning a defamation case because they have to prove that the defendant acted with actual malice. In special cases, defendants are given extra protection against defamation. In courtrooms and legislatures, speakers have absolute privilege, meaning that they can speak freely so long as what they're saying is true. False imprisonment is when someone is held against their will without reasonable cause. An employer, for example, who doesn't let an employee go home when he or she is sick is guilty of false imprisonment. If a police officer detains someone with no reason to suspect him or her of a crime, this is false imprisonment. In general, a store can detain a person if they suspect them of shoplifting if there's a reasonable basis for the charge. It used to be that no recovery was allowed if the injury was only emotional. Today, most courts allow a plaintiff to recover from a defendant who intentionally causes emotional injury, but the injury must be extreme and outrageous. Battery includes touching someone in a way that's unwanted or offensive. The touch doesn't have to hurt the victim. Sexual touching is offensive, but not necessarily painful, but it's still considered battery. An intentional action that does hurt some is also considered battery if it's unintentional. Assault is an action that causes the victim to fear an imminent battery. Assault can occur without the battery ever actually happening. For example, if you pulled a gun on someone, even if it's not loaded, this is considered an assault. Trespass is intentionally going onto someone else's property uninvited or remaining after they've asked you to leave. Keeping an object like a car or truck on someone else's land and refusing to move it is also trespassing. You might also be trespassing if you go onto someone's property mistakenly believing that it's public property. Conversion is taking or using someone's property without their consent. Fraud is injuring someone else by deliberate deception. A jury may award payment for injury to a plaintiff who wins in a civil suit. The single recovery principle states that the court must decide all damages, past, present, and future, at one time and settle the matter for good. Damages may include money to recover loss like medical expenses, to restore lost wages if the injury kept the defendant from working, or to compensate for pain and suffering. The purpose of compensatory damages is to help the victim recover what was lost, but punitive damages are intended to punish the guilty party for conduct that was outrageous and extreme. It's designed to keep the defendant from doing it again. It's also meant to make an example out of the defendant to prevent others from doing the same thing. About half of the states have passed limits on tort awards. In most cases, a jury can award whatever seems reasonable for economic damages. Non-economic damages usually can't exceed a prescribed limit, however. Intentional torts that occur almost exclusively in a business setting are called business torts. Someone can file a claim if they experience interference with a contract or a prospective advantage, or if someone has violated their rights to privacy and publicity. The Lanham Act, passed in 1946, prohibits and punishes businesses who make false statements intended to hurt another business. To win a case under this act, the plaintiff must prove that the defendant made false or misleading fact statements about the plaintiff's business, and that the defendant used the statements in commercial advertising, and that the statements created a likelihood of harm to the plaintiff. Interference with a contract exists if the plaintiff can prove that there was a contract between the plaintiff and a third party, and the defendant knew of the contract. Also, that the defendant induced the third party to breach the contract or make performance impossible, and that there was injury to the plaintiff. The defendant can justify their interference if he can prove that he was protecting an existing economic interest, or that he was protecting a public interest, or that the existing contract could be terminated at will by either party. Interference with prospective advantage exists when there's a relationship which gives the plaintiff a reasonable expectation of economic advantage, even though no contract exists, and when the defendant maliciously interferes and prevents the relationship from developing. The defendant can justify the interference if he can prove one or more of these elements: that he was protecting an existing economic interest, or that he was protecting a public interest, or that he was simply competing for the same business in an allowable business situation. Intrusion, or prying into someone's private life, is a tort if a reasonable person would find it offensive. For example, if your landlord taps your phone, or an ex-girlfriend or boyfriend stalks you or peeps in your windows, this is intrusion. Technology is creating new ways for a person's privacy to be exploited, which has forced the need for new laws, like the Electronic Communications Privacy Act. This act prohibits interception and disclosure of wire and electronic communication. And the Stored Communications Act prohibits the unauthorized access to a facility through which an electronic service is provided. Commercial exploitation is when a person's image or voice is used for commercial purposes without that person's permission. A wide variety of intended acts can have unintended consequences. With intentional torts, the defendant may not have intended to harm the plaintiff, but her deliberate actions have resulted in the alleged injury. Anticipating the harm that can result enables us to consider carefully the actions themselves.